You're listening to the Immigration Lawyers Toolbox podcast, the podcast that keeps your practice sharp and your clients happy. I'm your host, immigration lawyer John Khosravi, and every week we're bringing you insights, tips, and real world conversations with top immigration attorneys and industry leaders. Whether you're here to grow your practice, stay on top of the latest trends, or get inspired, you're in the right place. Ready? Let's go. Hello, fellow Toolboxers. Welcome to episode 399 of the Immigration Lawyers Toolbox podcast. We're almost at the 400 mark. Big deal. So that's going to be really cool. Let's see. Am I connected everywhere? Because we're going live as we do on Mondays. You can watch a recording of this on YouTube. It goes live primarily on LinkedIn and on Instagram, which I do recommend following our Instagram page. It's pretty popular. And then the audio goes where you watch audio or listen to audio on YouTube as well. But you can watch it live when it happens on Mondays. Before we start, I want to mention Circle Out ISO Community. That's our private community page, and we have a lot of free material like 245I explanation hour on that, religious worker visas now we're on that, NIV waivers. Those are it's probably getting harder and harder to do, but nonetheless, it's a big part of practice for some people, but most people don't know how to do them. That's just like it's the way it works out from my experience, like myself included. We're not big waiver and non-immigrant waiver and stuff. But Daniel Parisi had a great session explaining how those works. He does a lot of those. He's in Europe, big part of the Rome district. They have the actual Rome district chapter of ALA has a big conference coming up. Something to look into if you want to take a vacation, go to Germany. I think it's in Frankfurt. I'm going to be reaching out to them to interview a couple of people. So that's there. But going back to the community page, Circle.so, I really recommend doing it. It has a discussion page. I'm developing it as an alternative, and we're developing everyone who's part of it as an alternative Facebook to have things there. And it's just a page that's more readily digestible. It's based on timeline. Because on Facebook, on the groups, if you post something and then you go back to find it, you never find it ever again. But here's timeline. If we see some information coming up again, we'll just write up a white paper and have it there to answer people and just better management in that sense. So we also have a lot of white label content. If you want to give marketing material out, we have samples that I do my firm. I give out handouts to clients, sample checklists, that you have all that kind of stuff. And really cool is the AEO decisions. This is where you could review like NIW, EB1A court decisions, not court, at AO, Administrative Appeals Office. Now there's hundreds and hundreds of thousands of them, but we're using AI to narrow them down and to get them out to you, and then breaking down based on jobs so you can quickly find stuff, see the important notes, and see if it's worth reading in the first place. So that's something cool that exists, and that could really help you out. And the premium courses are there too. EB1A course that came out, very popular. A lot of people reaching out about that. E2 Investor Visa. We were doing a long running live only course, but I finally recorded it. You'll have access to it there. It's premium course. Go to the landing page there if you're already a member of Circle S so you can see how the background is. On our website, iltbox.com or Immigration Lawyers Toolbox, I made a basic landing page for these so you can check it out there. Just click on courses and check out our various courses, and more stuff's coming up soon. Like a consular processing course that we're separating, putting out there, but a core course is marriage, immigration, adjustment of status, affidavit support, consular processing, 212 admissibility, what happens after approval, I-751. Just goes, it's a masterful course. But having said all that, none of the information provided here is intended as individual legal guidance. Please consult with an attorney about your case. But you all know that already. Let's get the show started. So first thing I want to mention is the post I saw where someone said a client got their H-1B extension denied because they were on vacation or essentially working remotely from India, and they were outside for so long. They went to extension. They said, no, you were working off site. That's not allowed for you to work on like long term like that. I was like, oh, wow, that's pretty nasty. I don't personally do H1Bs. My associate does them, and we're not like a volume kind of H1B firm. So it doesn't come up for us a lot, like a situation like that. But then I saw some other posts. People were saying, oh, no, that's incorrect. That's not the rule and stuff. So I don't know which one it is, but just be careful when your clients are out, even if they're on like F1 OPT, for example, they spend too much time out. That absence could be considered unemployment for more than 90 days for basic OPT. So it's something to be very careful of. Number two is something I don't like reporting on because it's going to cause a lot of fear, but it's just got to be said because it's kind of a messed up situation. Is the amount of people coming forward more and more? It's still anecdotal. It's like you hear one a week or something, but it's more than enough, I guess, where they have like a adjustment of status case pending and they get an NTA to appear in court. Now, these are like marriage U.S. citizen cases. They're essentially most likely going to get approved. And the policy of all administrations has been to like just let these go until a decision is made. But we got a notice last week, not us, but like someone posted that they had a case where the O1 had expired while the adjustment was pending, and they got an NTA from the National Benefit Center. And then another one just got posted very recently, and this is stupid, frankly. A person was on a K-1, got married within 90 days, as the rules require, and then filed for adjustment of status. Inevitably, on every single fiance K-1 case, they will be out of status with adjustment of status pending, which kind of goes to show it was Congress' intent. Potentially, you could argue that people out of status but with an adjustment case pending are allowed to not be NTA'd essentially, because it doesn't make sense to create a visa category that's going to send you to court. They might as well just get married, not do a fiance visa, because if you go to court, it's just that the whole issue of NTA costs and hassle and being detained potential, all this kind of stuff. It doesn't make any sense to have that. So but apparently, someone said they had a case where he came in. Couple filed a case within 90 after 90 days. Married is 90 days. And filed was about a month after. They filed a month after the 90 days was done. But that shouldn't matter. The timing of the filing for a married U.S. citizen case, whether within 90 days or afterwards, it shouldn't be a factor in that. So that's a really messed up situation, extremely messed up, and that's just that we're dealing with until some lawsuits happen. Number 3 tip, actually, I didn't do a good intro. It's a top 10 tip day. Okay, so okay, number 3, new bond program. So this tourist visa situation, they made a big hubbub that they're going to create a bond system, and they're going to like test it out. What do they call it when they want to test it out? Trial program, if you will. And finally listed the countries. There are 2 countries in Africa that already had low visa numbers anyways. The pilot program is what they call it. So, but this is going to be a crazy rollout if it happens. They want like 5, 10 to 15, averaging, they say 10,000 dollar bond for people who want to come on a tourist visa. Now, if this gets expanded, it's really going to hurt the economy. Already, tourism's down. Vegas is shot, and all these other places right now. LA, where Hollywood has essentially vanished, we have a situation that's like people aren't going to be able to work, and the tourism industry was their backup to Hollywood, and that's not happening too. So it's a very bizarre situation, but that pilot program's there, and we'll see what happens. Tip number 5. This is kind of various things under CISPA. So it's actually 3 subcategories, if you will. So the Child Status Protection Act, you're already familiar with it. It's when someone's part of a dependent or derivative, a younger person under 21. The age goes over 21. It's a process to keep him as part of the case, even though they've been out, they aged out, if you will. Well, first thing is, I had a consultation, and usually when I have these consultations, more often than not, the people aged out and only do the system calculation as the work. This one, I did the calculation with the information they sent me at first. I was really happy to report to them that even though the kids were like 28 and 32, the other one 30 took so long that they were still part of the case. They just needed to pay the fee and they were locked in. And as soon as the visa bulletin was going to get current in a while within the time, so it would work out. But then after talking with them, they're like, "Oh yeah, by the way," I'm like, "Okay, as long as you're, CISPA qualified or 21 and unmarried." They're like, "No, no, no, we're married." I was like, "Oh my god, you can't be unmarried child. That's not going to work." So I asked ChatGPT, I'm like, "Is that the rule that you can't be unmarried? Could they just get divorced instead?" And ChatGPT is like, "No, you can't get divorced. That's not possible." And I was like, "This goes to actually a theme we have every week of something ChatGPT told me that's wrong." So this is this August 11th version of it. But then I studied and studied and looked, and I found the FAM. It says 9 FAM 502.1-1D6, impact of marriage or divorce on CISPA. And I'll read the law. It's kind of cold, but let's do it. It says, while the CSPA CISPA may prevent the applicant's age from changing, the applicant must still meet the other criteria for child status, being unmarried. If the applicant marries, the applicant will lose child status, even though the applicant's age for information purposes may be under 21 for CISPA. A divorce, this is the part, a divorce that occurs after the child's 21st birthday and after the visa becomes available will not restore the child status because the applicant was married when a visa was available. In this console that had a visa wasn't available yet. It's like 6 months behind, but they had like 2.5 years for it to move forward. So it's probably going to happen if they get divorced in time, according to this. However, if the applicant divorces before the visa becomes available to the applicant as either the principal applicant or the derivative applicant, then a divorce may restore the applicant to child status if the applicant CISPA age is under 21. It's like, oh, that's pretty magical. ChatGPT got it wrong as usual, but that's pretty cool. But now it's like, so they have to get divorced, and is USCIS got a problem saying this divorce is happening just for Child Status Protection Act? The regulations loud. Why would the FAM say it? I mean, that's intentionally says you play this game. But my also side worry is like, what if they get divorced? Okay, they even get the green card, and then they turn around and get married. Is that going to be a problem for USCIS not accepting the marriage and stuff? I don't have an answer. I've been able to find it. Someone posted on a Facebook group I posted that they'll consider that like a sham divorce or something. But why would it be? It's just a technical, strategic thing to do. Divorce is divorce if the court recognizes there's no sham. So I'm like, as a client, say, like, are you down to get divorced for this? Because I spend more time doing research on this, but I got to stop right now because I haven't been able to find the answer. I thought it would be easier to find it, but I'm going to pause it and see if they want to have more consults to figure this out. But if they're not going to get divorced, if their wives aren't down with it, then there's no point. But I want to share that with you. It's kind of crazy situation. Now, let's go to section 2 of our CISPA situation. Derivative status for children, spouse and children, family purpose qualification. One thing about the previous one was that was interesting that the age has to be under 21 and the visa can't be available when they divorce. So the divorce has to be completed, and sometimes divorce takes a while in some countries before the visa becomes current. All right, number three, under such circumstances, however, the petitioner could elect to file a separate petition for any of their children. Okay, so this is interesting because let's say they were married and they had a kid, or they didn't get married, but they had a kid. That child, here is the part where it says the child, like essentially a grandchild, could come part of that petition as well. If it's really F1 and F2, F3, F2B cases. Derivative status for spouse and children. Under such circumstances, however, the petitioner, and it's not FAM 502.2-3, sorry, it's jumping around a lot. I'll put that in the show notes. Um, However, the petitioner could elect to file a separate petition for any of their children who have children of their own. With a separately approved petition, the petitioner's child will be the principal beneficiary of the petition, and accordingly, the child's children will qualify for derivative immigration status through a principal beneficiary parent. And after reading this, is dancing. You're not reading right now. I'm having a hard time understanding. Potentially, there's a way to get kids in there. I don't want to spend too much time on it, but know these options exist. It's in 9FAM, 5502, not in 50. Essentially, 9FAM 502 has this child status stuff. You got to read and reread it. Child Status Protection Act, every time I get into it, I got to like go back to my notes and start from zero to build it up. I don't know why it gets this complicated, but that's what it is. And C, this is like I was talking. Which one was I was problem with? But like I was saying something. Oh no, it's a different section. I'll talk about it later. But number C is speaking of Child Status Protection Act. I have a case where they came to me. It was a LPR F2A filing for spouse and minor child. Didn't know the rules. Naturalized, became a citizen. Small child who was not doing well health wise. A couple years old. Fell out of the case. We got an I-130 expedite for the child, and but the embassy will not expedite it to get an interview. It was a child, essentially. It's a interview waiver. I don't know. We've tried several expedite requests through senator, congressperson, the NBC. We're going to go out every 30 days, keep pushing him. But it's kind of crazy when you see this stuff happen and everyone's calling about expedites and stuff. I'm like, when I see this scenario where the child has issues and doctor's letters and tests and all this kind of stuff, where they don't care enough to expedite a child's kid in this embassy, it just breaks your heart and it keeps you, open to what the situation is with these embassies. Sometimes it's very heart wrenching how they're doing it. All right. So number 5. Let me see. There's the one I wanted to talk about. Okay, I'll talk about it later. Okay. So number 5, we have a great colleague. Actually, I'm going to interview him tomorrow, my time. I'm not sure where it's going to be posted. But Daniel Kowalski was a practitioner, a partner at David Ware. I'm going to catch up on his background because I haven't looked him up in a while. He has a Substack called Involuntary Departure, and he definitely follows LinkedIn page. We'll have it in the show notes. He had a clip on his LinkedIn page that I'm going to read. It's about bond hearings and stuff like that. And some people posted saying, no, I'm not sure where this 10,000 number came from, but we'll go through it. It's interesting to hear. It says, bond hearing pro tip from a very smart colleague. This morning, the colleague says, I did a bond hearing where I knew the issue would be mandatory detention under the new scheme to call everybody arriving aliens. The judge found that my client wasn't a flight risk or a danger. Then we got to the jurisdictional issue of 235I versus 236. And it turns out the arrest warrant indicated that he was removable under 236, which the judge found was binding on the DHS. Therefore, only non-bondable if aggravated felony or terrorist by discretion. So the judge ordered a bond, but before she said how much, I interrupted her and said I wanted $10,000 bond. She said she was prepared to order $1,500. I said that if the bond was under $10,000, the other lawyer, and the government appealed, which obviously they're going to do, then the bond decision would be stayed on appeal if they filed the EOIR 43 timely. Of course, the OCC, which a moment earlier was arguing that my client was a danger to the community because he had a DV arrest 12 years ago, now is trying to argue that $10,000 was too much of a bond under the circumstances. Incredibly, they did this with a straight face. Anyway, I got the $10,000 bond. The client is paying it as we speak. So the moral is don't ask for bond under $10,000. And so it was interesting. I don't really know bond hearings, but I thought it was an interesting tidbit to share. And some people were saying, you don't, that number is not per se sacrosanct and stuff. but just interesting to know. Now, what I do know is EB1As, E2s, marriage immigration, consular processing. We have the courses for you. And interrupt our broadcast really quick, just to remind you, and just join our community for free. You have to be a U.S. immigration lawyer, but we have a community page. Circle.so is the website that hosts it. But we have discussion pages and all the like. And again, you can learn how to do EB1A. We have premium courses for that, but also a lot of free courses, CLEs at 245I, NIV waivers, practice management, all this kind of stuff. It's really, if you're an immigration attorney or you're a lawyer looking to be an immigration lawyer or handle that, 100% the place to add and join. And there's a lot of tons of information there in that community. So if you want to join, our website had go to IELTS, just email me info@immigrationlawyerstoolbox.com and send me your bar information so I know you're a lawyer and we'll get you in. Number six, and this is just a shout out to our friend Greg Siskin and a lot of other people are working together. A while ago, it was ICE did this thing where they just revoked a bunch of F1 visas ridiculously. And like, oops, I think they used some sort of AI system, just cut people out. But that was fixed. But a lot of people got really screwed over in different ways. And so they are doing a lawsuit now saying if you're an F1 student who was incorrectly revoked, we're suing over that issue. This is the second part of our litigation in which we successfully sued to have CBIS reinstate for hundreds of students. Charles Cook, Jesse Bless, Aaron Hall, all getting together their firms to file this lawsuit. I'll have a link to the LinkedIn page where you can get a hold of that lawsuit, give your clients if they're part of it, and help restore some justice in the insanity that happened in the ICE and F1 CBIS system. Number seven, this is the one that I wanted to mention. So last week, I was talking about reviewing statistics from the Department of State about different things they have, and one interesting thing was like if the Department of State gets a waiver from an interested agency or an embassy, a foreign national embassy for a J1 2-year home residency requirement waiver, they almost always will approve it. It's very rare that they don't. So I'm going, that's a happy spot in there. And it seems the administration may have been watching or something, because immediately after I said that, they started doing denials. The OS started issuing denials of the J1 approvals from embassies. And AILA did a call for examples of this, saying AILA has received reports that the Department of State's Waiver Review Division, WRD, is refusing to issue favorable recommendations for J1 no objection waiver requests, even when no objection statements from the home country have been submitted. So this is something that I'm collecting examples of. And right after I said that, saw this, I got a person who contacted me saying his J1 was approved by his home embassy, but the US denied it. And I said, let me look at it. And the letter, where did I save the letters? Where did I put it? I can't show it because I got the person's confidential information, but I think I sent it team wide, our personal team. The language on it is really harsh. That I wasn't expecting. It's just like you could tell this administration did it. Let's see this reply. Did I post it here or somewhere else? So it says, Dear Director, this is now it comes from waiver. It's out to the Vermont Service Center, DHS USCIS. This is from the Waiver Review Division. Dear Director, after a thorough review of the program and policy considerations in this case, so the review of the program, the policy considerations, not about the applicant, it is the department's recommendation that the waiver be denied and that the exchange visitor should return to their home country, thereby fulfilling the purpose and intent of the Mutual Educational and Cultural Exchange Act. This concludes the department's involvement in this case. Any further action concerning this case falls under the jurisdiction of USCIS. So, as a policy matter, they're going to be denying these, and that's a lawsuit. I mean, this thing does exist, although they have like discretion in certain cases, I guess, to deny the 2-year home residency waiver. It exists for a reason. I mean, Congress made it. I haven't read the statutes. I'm assuming it's statutory. So there are regulations that permit it. For them to say as a policy you don't want to, I mean, they're trying to get rid of birthright citizenship, which is like the law of land. So this is just another piece of insanity that we're dealing with the administration. Number 8, which is a good spot. I saw this last Trump administration too. It says New York law schools see new interest in immigration classes and clinics, booming interest in becoming immigration lawyers. BloombergLaw.com is reporting. So that's a great thing that exists there. And that's the toolbox really came out of that last Trump administration. A lot of demand, partially one of the reasons we made the toolbox for training and this kind of stuff, because so much demand for learning immigration law, getting into it. So although a lot of the old timers and medium timers are getting pretty burned out and frustrated, fresh blood is always good. It brings the joy and naivete to it too. It's not as stressed out and jaded. So it's good to have that, and it's inevitable. People fight back, especially when it's crazy at this administration doing it with their actions, just out of control. There's like wise ways to do stuff, and there's the ways they do them. So it's unbelievable. Number nine, Australia updated its police certificate requirement. U.S. Department of State has quietly changed, not Australia, Department of State, updated the visa bulletin saying the police certificate required for Australia is now to require a fingerprint AFP check rather than a name check, only police certificate. This has created a more complex and longer process. And so be very mindful of that. It's going to take longer if you have an Australian case. This is courtesy of our great colleague in Australia, Sherwin Nurion. He has a practice there. He helps a lot of people constantly processing U.S. lawyer. Have his contact info plus this post he had on LinkedIn there. It's very helpful to have this kind of information. They change this stuff on us all the time. They changed the Pakistan police certificate requirements. Say it was not required to required back in June without any fanfare. Now they changed Australia's. We're going to advise clients, for example, go do this and it's the wrong one and push case online. That's why the immigration law, you got to really be on top of it and constantly be studying it. And that's what we're here to do to help you with that to become better immigration lawyers. So just stay tuned. We have more and more information on this. Number 10, there's a worry I had that the CHMB case I had and a Venezuelan case I had would not be approved, marriage-based adjustment of status. But I'm happy to say they were both approved. There were no holds. Took a little bit longer than not even usual, just a little bit long. Not a same day approval, but a week and a half later approval, which is kind of not too off the standard nowadays. So that's good news to hear. These people who are on these programs that they're not on hold. Essentially, that's the main thing that I was worried about. It's going to go on forever, and that this time their status expired. They may be detained or something, but green cards were issued. Very cool. And speaking opposite of cool, it's a bonus point. I saw this report on Deutsche Welle. I think that's like Germany's BBC on YouTube. And it said it is regarding international immigration. I know I focused almost 100% on U.S. immigration in this program, but the global movement of people is part of what we do inevitably. So global migration is something I'm going to talk about more and get back into. And here, it's somewhat close to home. Um, Iran expelled about a 1.5 million Afghan migrants who lived in that country, some for like 40 plus years, back to Afghanistan in the havoc that it is. After the war with Israel, for various reasons, they, accusing you of bad stuff or spying or other kind of reasons. The economy is horrible there. Inflation is like crazy. They expelled these people that had homes, cars, jobs, small kids, families, and they just sent them go to Afghanistan. Sometimes people have to leave everything they had behind, major loss. So it's a very sad situation to see that happen. Very depressing. I was sad to hear that that the Afghans had to go through that. The Afghans are, Iran and not that distinct of people. So to see that happening to essentially one people kicking about is very sad. Especially for me and my Iranian background to hear that. So I'm very sad. I'm not living there. I don't know what people are dealing with on a daily basis. For me to sit here in LA to say something's bad about, take it as you will. But nonetheless, I was hoping there wouldn't be a situation like that, especially with the Taliban ruling things. And they're going to go there with the Iranian background. Taliban's going to probably treat them like crap too. So it's just a no-win situation. God willing, they're able to make it work. So on that very high note, thank you so much for listening to the Immigration Lawyers Toolbox podcast. We try to keep it real and just tell my thoughts and try to speak into the microphone and hopefully speak slowly so people can understand what I'm saying. But I'm here every Monday talking about top 10 things I learned last week to share that information with you. And we're doing tons of interviews with new people, regulars, with tech people, business people, management, office management people, and all the like. Our familiar names, Ruby Powers, Roman Zelichenko, Gianfranco DeGirolamo, I'll get his last name right one day. And I'm going to try to get Nadine Heights on again. So a lot of regular interviews. Kevin Gregg is always very kind for Immigration Podcast. All these people will have their own podcast for the most part too. So you listen to theirs. But we're getting all the brain trust of immigration in one place to help you expand. And we're adding courses too. So definitely reach out. And if you're interested in doing a course too, or writing an article for the magazine, whatever we do could promote you, because promoting you and yourself will help promote the practice for people to become better immigration attorneys. And that's, in the end of the day, the goal here, to create a number one level field and system, to know that of all the lawyers in the game, immigration lawyers are the best, and we're going to get there. Thank you so much, and see you all next week. Bye-bye. If you like this episode, follow us on Instagram. Our handle is Immigration Lawyers Toolbox, where we post the latest statistics, tips, and more. And stay tuned for more from the Immigration Lawyers Toolbox podcast.